Partnership dissolution. This is part 4 and the last part of our partnership discussion. Okay, so remember, a partnership can be dissolved at any time. A partnership is an at-will entity. So a reason for dissolution, the partnership can be dissolved when a partner leaves. So remember, under the Uniform Partnership Act, if a partner leaves, what automatically happens? That's right, the partnership is dissolved and it enters the wind-up and termination phase. Under the Revised Act of 1997, what happens instead of dissolution? That's right, dissociation occurs, not dissolution. Under the UPA, the partners have to reform a new partnership. Under the Revised Act, they do not. The partner is dissociated when they leave. Okay, now, there are certain circumstances in which a general partner can dissociate from a partnership, and this will also trigger dissolution. Dissociation will trigger dissolution, wind up, and termination under the revised general partnership under these 3 circumstances. They are easy. 1, the leaving partner decides to force liquidation. That sounds harsh, but remember, a partnership is an at-will entity. In an at-will partnership, the dissociating partner can just leave, or the dissociating partner can choose to dissolve the partnership. So that's circumstance number 1. Circumstance number 2, is the partnership for term or for a purpose, and that purpose is fulfilled. Then the partnership is dissolved. And circumstance 3, there's a triggering event that triggers dissolution. Okay, when does dissociation of a partner trigger dissolution of the partnership under the revised Uniform Partnership Act? 1, in an at-will partnership, the leaving partner decides to force liquidation. 2, the partnership's term has ended. Its purpose has ended. It's gone. Or there is an event that triggers dissociation. 1, at-will partnership. 2, partnership for term or for a purpose. 3, triggering event. 1, at-will partnership. What's the rule? The leaving partner decides to do what? That's right, force liquidation. If it's a partnership for term or for a purpose, when does the partnership automatically dissolve? That's right, when the purpose is completed or when the term is finished. Or there is an event, a triggering event. When that event happens, dissolution is automatic. So remember, in an at-will partnership, the remaining partners can continue in the partnership, or the other partner can force judicial dissolution and liquidation, right? What happens if the partner just dissociates? Does he get anything, or does he just walk away? No, the remaining partners have to buy that partner out. Under the revised Uniform Partnership Act, if a partner dissociates and that dissociation is not wrongful, the remaining partners must buy the other partner out. Okay, so what do we have? At will, the leaving partner just decides to leave, or they can force liquidation. If they just decide to leave, you've got to buy them out. Number 2, partnership for term or for a purpose. Purpose is fulfilled, term is ended. And 3, dissolution based on an event that triggers dissolution. Okay, so there is rightful dissociation and wrongful dissociation. When a partner dissociates, he can do so rightfully unless one of those 3 circumstances are present. He didn't complete the term. The partnership purpose hasn't been fulfilled. the triggering event didn't happen. That would be wrongful. But the number one reason, and this is the rule I want you to remember, the rule for wrongful dissociation is the partner breaches an express provision of the partnership agreement. Wrongful dissociation equals the partner breaches an express provision of the partnership agreement. The partner does what? He breaches. What does he breach? Not just any provision, but an express provision of what? That's right, the partnership agreement. And of course, the partner can withdraw. It would be wrongful for them to withdraw before the term expired, the purpose is accomplished, or they're expelled by a judicial order, there's some sort of wrongful conduct. And the other exception is if a partner becomes a debtor in bankruptcy. Okay, but our wrongful dissociation rule is that's right, the partner breaches an express provision of the partnership agreement. Okay, what happens with wrongful dissociation? Well, remember, if the partner just decides, I don't want to be in this business anymore, I'm walking away, the other partners have to buy him out. But if the partner caused the dissociation wrongfully, they became a debtor in bankruptcy, they breached the partnership agreement, they withdrew before the purpose was accomplished or the term was fulfilled, the partner is liable for damages caused by the dissolution in addition to any other obligation the partnership has and obligations to other partners. If you are a partner and you dissociate wrongfully, you as a partner are liable for damages caused by the dissociation and any other obligations to the partnership and other partners. So you are wrongfully dissociated. What do you owe? Damages caused by the dissolution to any other obligations that you owe to the partnership, that's right, and to the other partners. Okay, so remember, a partnership is an at-will entity. So just if you withdraw by will, that's not wrongful. The partners have to buy you out. But if it is wrongful, you're going to owe damages and you're going to have to complete your own obligations to the partners and the partnership. A partner can also be expelled in a couple other of ways. So we talked about dissociation. Partners can also be expelled. If they breach the partnership agreement, they could be expelled pursuant to that agreement. A partner can also be expelled by vote. What kind of vote do you think we need? That's right, a unanimous vote. Remember, decisions outside the ordinary course, unanimous vote. Expulsion of a partner, unanimous vote. Expulsion of a partner pursuant to the partnership agreement, expulsion due to unanimous vote, or there's your judicial expulsion. The standard here is wrongful conduct that materially and adversely affects the business. Wrongful, what? That's right, conduct which materially and adversely affects the business. Number 2, breach of the partnership agreement. Number 3, a breach of a fiduciary duty can cause judicial expulsion. If a partner becomes a debtor in bankruptcy, the court can expel him too. Or of course, there's the catch-all. It's not reasonably practicable to carry on business with that partner. Okay, so we've got our expulsion pursuant to the partnership agreement. We've got our expulsion due to unanimous vote, and we have our judicial expulsion. Our judicial expulsion is partner's wrongful conduct materially and adversely affects the business. Materially and adversely affects the business. The partner breaches a fiduciary duty owed to the partnership. And our catch-all, it's not reasonably practicable for us to carry on business with you. Okay, dissolution is not the end, is it? Because dissolution triggers what? That's right, winding up and termination. Only after the partnership completes all of its business and winds up all of its obligations can we move to the termination phase. However, dissolution triggers something else. It terminates the authority of partners to act on behalf of the partnership and bind the other partners. Sorry for this noise. Okay, dissolution. We go to the winding up phase, we complete the obligations, partnership terminates. Once we hit dissolution, what happens to the authority of the other partners? It is terminated. The dissolution terminates the authority of the partners to act on behalf of the partnership. They cannot go out and make contracts. They cannot go out and do things that bind the partnership. Their authority it no longer exists once the partnership enters dissolution. There is an exception, of course. The partnership does have the authority to conduct affairs that are necessary to wind up and terminate the partnership's business. So here's our general rule. Dissolution terminates the ability of the partners to bind the partnership for new things, new contracts, new leases. But the partners still have authority to conduct the winding up of the business, complete projects, fulfilling obligations, paying debts. Okay. Now, as such, guess, are the partners still jointly and severally liable during the winding up and termination phase? Yes, they are. The partners are still liable for any acts, omissions, or obligations created in furtherance of winding up the business. When you wind up the business, remember the partners don't have authority to do anything new, no new business, but the partnership can wind up its old business. And while it does so, the partners will be liable for any actions that they do in winding up the business. What are we talking about? Contracts, torts, obligations, anything that they do in the winding up process, they will be liable for. Okay, there is one exception to this rule because there's always an exception. In the winding up of the business, partners are allowed to do actions necessary to maximize the partnership's value at liquidation. After all, the partnership is an investment. So the partners may act to enhance the partnership's value at liquidation. Okay, let's run through dissolution one more time. Dissolution terminates what? That's right, the authority of the partners to engage in new business. But it does not terminate, that's right, the authority of the partners to do actions that are necessary to wind up the business, fulfill contracts, pay debts, sell assets. And accordingly, what is their liability? The partners will be liable for their acts, omissions, and obligations created when winding up the business. The only thing that they can do affirmatively is things that enhance the liquidation value of the business. In winding up of the business, the partners may act to enhance the partnership's value at liquidation. Okay, so moving on. Remember, a partnership is an at-will entity, so a partner always has the power to dissolve the partnership. You can't force a person to carry on as a co-owner of a business for profit against his will. However, if a partner dissociates and dissolution results, we've seen already that legal consequences can follow. So when the partnership doesn't specify, we said that one of the reasons for wrongful termination, wrongful dissolution, was when there's the partnership for term or for an undertaking. So in a partnership at will, is dissociation and dissolution a breach? No. Dissolution in itself does not contravene the partnership agreement. If the partner just withdraws by express will, that's not a breach. Remember, a breach is some sort of willful or persistent conduct or a breach of a fiduciary duty. Okay, so talking about rightful versus wrongful, we're going to focus here on the revised Uniform Partnership Act. What is always wrongful? Breaching the partnership agreement, breaching your fiduciary duties, becoming a debtor in bankruptcy, getting expelled pursuant to the partnership agreement or judicial order. Who's liable to who? Remember, if it's a wrongful dissociation, the partner is liable to the partnership entity. For what? Damages and any other obligations they owe to the partnership and the partners. Okay, under the revised Uniform Partnership Act, remember, dissociation doesn't automatically trigger dissolution except in the three circumstances. Partner decides he wants to force liquidation, the partnership is for term and the term is over, the purpose is fulfilled, or the triggering event. So if a partner dies, becomes incapacitated, becomes a debtor in bankruptcy, or is expelled, what happens to the partnership? It continues as an entity. The distinction between the UPA, the aggregate theory, is that when the partner withdraws, automatic dissolution. For the revised Uniform Partnership Act, the distinction is the partner withdraws, triggers dissociation, unless we have one of those three things. And if the dissociation is not for cause, not wrongful, then the partners have to buy out that other partner's interest. Okay, last bit of partnership law are our special rules for limited partnerships, and that's our next video.